Assalamu alaikum students, how are you? I hope you all will be fine. It's the second lecture. I am here at Seeds School of Business and Law. We will be discussing the offer today. In our previous lecture, we have discussed that what is contract and how it is made and what are the essentials of a contract. Now we will discuss the second chapter offer, but before that we will know that what are the kinds of contract, what are the types of contract. So let me start it by the number of people, number of parties involved. So we will discuss the contract and its kinds. Firstly, we will distribute them among the parties. So we will distribute them on number of parties involved. So firstly we have unilateral contracts. Unilateral contracts are those contracts which is done by only one person, one party. One party has given certain things to the other party which has then they have to perform. It is as a result of, as a reward, we can say that, for example, A has lost his watch and he has given a statement that if anybody finds that watch for me, then I will pay them £100 or £50. So they set a reward, and on this statement, if someone has acted and then find the watch for him, then it's called a unilateral contract because it only involves one party to have said something, and if the other party has done in accordance with that thing, that reward, then he should be paid, right? So it was a unilateral contract which only one party is involved. It has work as a reward. It also work as a advertisement. If we have seen an advertisement and it induced us, it has influenced us, and we have used that product and they have said certain things that it will help this and that, and if they don't, then we can sue them. Just like we have a case of Carlyle versus Carbolic Smoke Ball Company Limited. As we have already discussed this thing in our AS course, A2 course, A level course, we will know that it's a case in which a product was presented in a market which explained that if you use that product, it will help you reducing your disease, and if and one person has used it and it doesn't have that impact, so he sued, and the party which sued the Carbolic Smoke Ball Company Limited, they have won the thing because they have act as advertisement, and it was a unilateral contract for all of them who is using them, and when they used it and if it doesn't work, then they can sue. So it was a kind of unilateral contract. Then secondly, when we say number of parties, we have bilateral contract, right? So what are bilateral contract? We have just discussed in our first chapter that A has £1,000 and B has car. So these both are liable to each other, and it is called bi. Bi uni mean one, bi mean two. When two parties involved, right? Two parties are involved and set obligations, just like A have to pay 1000 rupees and B has to give him the car. So it was a bilateral contract which is normally done, right? And we have discussed in the first lecture, so no need to elaborate this further. Then we have collateral contract. Collateral contracts are those contracts which add something, some new terms. When we add some new terms when added into a main contract, then we can say that it's an additional contract, and we can say that it is a collateral contract. When there is error in the main contract, then we can remove it by this collateral contract. And when we add another party, third person, when third person involved, then we can do this thing, right? So this can the third party when involved, then this can be also be done in a collateral contract, right? So these were the contracts and its kinds by number of parties. Keep in your mind, when number of parties involved, then we have unilateral contracts, then we have, secondly we have bilateral contract, and then we have collateral contract. Now we will know that if there is law involved and there is term and conditions involved, then what are the kinds of contract? Then we have three kinds of contract. The first one is a valid contract, right? Valid contract. When all the essentials are fulfilled, like I say, offer, acceptance, intention, contractual capacity. So when these all the essentials are fulfilled, then we can say it's a valid contract, right? So it was the first one, the valid contract. Secondly, we have a void contract. Void contracts are those contracts which miss any of these important things. When the consideration, which I have missed in this, is consideration as well. So when this consideration is illegal, when it is without intention, when the offer is not voluntary, and these basic things are missing, then we can say it's a void contract. It is not correct in the eye of law. Then we have the third one, we have voidable contract. Voidable contracts are those contracts which include something like mistake, fraud, misrepresentation, and one party has the right to end this thing or continue with it. So it is voidable. If the aggrieved party wants, then it can be void, right? So it was certain things regarding the contract and its kinds. We have discussed contract by legality. So we have valid contract, void contract, and voidable contract. And we have discussed previous to that the contracts by number of person or number of parties. We have unilateral, bilateral, and collateral. Now we will be officially moving toward our second chapter, and that is offer, right? So what is an offer? We will discuss it now, that how it is made and what is an offer basically. An offer is a proposition made by the offerer ठीक है, who is making the person making it, okay, made by the offerer, just like we can say one person, made by the one person, we call it as the offerer who is making the offer to the second person. Can I will light it? The second person, right, and the second person is offeree to whom this offer is made. So if there is an proposition is made by one person, the offerer to the other person, offeree, the offerer, right, the offerer is willing, right, the offerer is willing to be bound by the terms, to be bound, okay, the terms of a proposition if second party accepts, right. So we have known that now, till now, we can say that this definition is of offer. And offer is a preposition. I am saying something to you, the second person, a preposition made by one person, and that person who is giving the offer is called offerer, right? Offerer. To the other second person, the second person is whom? The second person is the offeree to whom it is made. So in the first case which we have discussed in the previous lecture, that was 1000 pound is given by A to B for his car. So the A is offerer, which is offering something, to B the car owner is offeree. The offerer is willing, just like we have seen in that case, that the offerer is willing to pay him 1000 pounds. So the offerer is willing to be bound by the terms. He is willing to bound himself of the preposition if second party accepts. Agar second party accept करती है, then we can say that it is an offer. So there are certain things which need to be fulfilled for an offer. So offer must be. How it is? We will discuss it now. That the offer must be clear, right? If there is ambiguity in offer and I am saying that I am giving you this car and I was not intended to give you this car and it was something else, so it is not clear. So the offer must be clear, precise. If I have a lot of cars, then I must be precise that this car is I gonna be sale. So the precising is very important. It will be clear, precise, and capable of acceptance. Capable of acceptance by the other party. If I am giving you, in Pakistan we have rupees, and if these currency notes are old, and I am saying that I am gonna give you 1 lakh currency note which are not usable now, so is it capable of accepting by the other party? No, it can't be acceptable. So these kind of things which can be accepted, just like it must be reasonable, right? If you are buying a car which worth 10 lakh and you are giving just 1 lakh rupees, then it's not good, right? So it must be capable of acceptance by the other party. Moving further, we will have other things which are like offer, but it is not offers. These statements are a statement of intention. I, in my newspaper, has put an ad that I want to sell my car, right? I have made an advertisement, so it was just a statement of intention, right? If somebody came to me and give me an offer that you have placed this car on 25,000 pounds, and I am willing to give you 25 pounds to 20, 200,000 pounds, etc., etc., then he will give me a statement and I will accept it. To mere statement of intention is not made an offer, right? Moving further, a supply of information. A supply of information. You went to a shop and you just inquired the thing, that how much is this cost. You just inquire about the things, and it is just only, and if the shopkeeper has given you information, so it's not a offer that he has made an offer. He has just given us information, right? When we go on a window shopping, we have asked certain questions from the shopkeeper, with how much it cost, how much is this, and when they give us information, or we have seen a display of car, display of garment, anything, and when we go that how is it, and he is explaining the things, he is just giving us information that these are very good quality cloths, the fiber is very good, it is handmade, etc. So these are just mere information, these are not offer. And when we ask them that what will be the lowest price on which you can sell them, then if they give us information, then it will be merely an information, not like I want to how much you will give accept for this. So you will say 20, 100 pounds, 200 pounds. So these are just information, it is not accepted by us. If it is accepted by us, then we can say that yeah, I want to buy it for 200. If you want to accept it, then we will offer them something. So a mere supply of information is not we can say offer. Moving further, we have invitation to treat. Let me rub it because it will be very down and I can't write very down. Okay, so we will discuss that what is an invitation to treat. An invitation to treat. Okay, invitation to treat. We have done certain things just like advertisement, which are offering us, which are certainly giving us information about anything. So all the advertisement are only invitation to treat, that I am giving you an offer. Just like few seconds ago, I have given an example that if I want to sell my car and I have put an advertisement, just like, then it will be only an invitation to treat, that if you are interested, then treat me. It's a kind of invitation that if you are interested, then give me an offer, right? So all the advertisements are invitation to treat, these are not offers, right? Moving further, we have a display of goods. Display of goods in shops. We have seen a lot of displays on shops. We gone through the market, we have seen certain things with a price tag. So it's not an offer that they are giving us an offer that go and give this money and walk away. We will go to the shop and we will have a say, and we have to present an offer that I want to buy this stuff and I like it, will you give it to me on this price? Then if he accepted or she accepted, then it is offer from us. It's not that they have given us the, we can say, the offer at first. It was only an invitation to treat, right? So it also include a tender. We can say request of tender. We have seen in the newspaper that the government authorities, local authorities have given a tender, or any private company, that they have given a tender that we have to buy this thing or we have to sell this thing, and then they have given us certain tenders, the tender notice, and then we have to apply. So these are not offers, they are just mere invitation to trade. Moving further, we have auctioneer request for bids. Auctioneer request for bids. So when there is request for bidding, that this is a thing and you came and have a bid, then it is called invitation to trade. These all things are included in invitation to trade and not are included as offers. So we have distinguished between invitation to trade, mere information about anything, and offer. Now we will know that how important it is to communicate an offer. So, Mirabit, communication. So the communication of an offer is very important. So all the things which I have given previously, that it must be clear, precise, and capable of acceptance. All the things are included here as well. That the communication must be clear, precise, right, and capable of acceptance. It will be communicated properly to the other person, and then when other person knows about it, then they will have accepted, right? And we will do the acceptance in our third lecture. Till now it was till an offer we have know about what is contract in the first lecture. Then in the second lecture we know that what are the kinds of contract. We have discussed that we have types of contract by the number of parties, just like unilateral, bilateral, and collateral. And then we know that law, when the law involved, then we have three kinds of contract as well. We have valid contract, void contract, and voidable contract. Then we came across the first essential of a contract, then that is offer. We know that what is offer and how it is distinguished by other things, just like invitation to trade, a mere information about anything, etc., etc. In the third lecture, we will be discussing that how it is accepted and what are the terms and conditions regarding to accept it. So that's all for today. Thank you so much.